Greetings, 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 greetings. I'm King Clifford Jefferson, descendant of Godfrey, the fifth counterbound Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know as the Vicar of Christ or Jesus Christ or Melchizedek, the King of Righteousness. It is July 4th, 2025, which is equivalent to the birth year 2975. I greet you in the name of my mother. I greet you in the name of my father. I greet you in the name of the ancestors, all those who have came before us, all those who will come behind us. I greet you in the name of all that stands in the name of the English people. I want to give a special honor to my queen, Sister Galveston from the House of Galveston. I'm going to give a special honor to my mother, Betty Ann Jefferson. She just made the transition to the transitional world today. So all those of the church, please pay your respect to the elder, Betty Ann Jefferson. She made the transition July 3rd, 2025, which is coming to the Berber year. So send your love and blessings to the world family. With that, let's get started with this marvelous lesson. The lesson is the 10th Amendment. This is how the English power will be returned. Once again, the 10th Amendment. This is how the English power will be restored. Okay? I will try not to hold you long. I will try to make it as quick as possible, but it's very relevant to the status of what's going on with the birthright citizenship here in North America in regards to who are actually citizens and non-citizens. I was expounding upon the things that I spoke upon in my past 3 lectures. It was very important to watch those lectures to understand this one. With that, we get started with this marvelous lecture. Tenth Amendment. If there are any questions, please post them in the chat. For all the newcomers, like, share, subscribe, as well as donate free and common focus to those who are able to. We do appreciate it. This is life-saving messages that you will never get from any other platform. It's truly an honor to be the child of a mother who has made the transition to the forefathers, because she can definitely be proud that one of her offspring has truly heard the begging call of that remedy that was promised a long time ago for one to be born of such magnitude, and such a magnitude of that entity being that of a king. Okay, it's very important to understand that. This lesson will be one of the best lessons that I ever done. All right, so with that, let's get started. Greetings, Brother Thomas from the House of Thomas. Glad you were able to join me today. I honor my mother's transition to the next plane of existence with the ancestors, which we all must make. But the gift of understanding are the treasure of the Creator, and He puts to everyone what measure seems good unto Himself. So once again, I'm just thankful to be a child of an earthly being, to be able to understand our stay here on this earth, and to be able to apply all the laws for us to continue to exist on the earth for all of our offspring. Okay, so this lesson is very tailored towards honoring the children of our mothers and fathers who are still living, those who have passed, and those who have as their life in our hearts, you know, in regards to what it is that we are obligated to do as children. Okay, how many of children have raised themselves to the magnitude of not just a king, but a representative of a nation? Okay, to remind them of the illustrious history that they once had and that they still have, but they choose not to possess it. All right. So it's very important to understand this lesson because we gave our rights away. All right. We gave our rights away. All right. They didn't take them. We gave it away. Let's prove it. It's all under the true understanding of the 10th Amendment, because once again, this is how the English power will be returned. Once again, like, share, subscribe. All donations are welcome. The 10th Amendment to the United States Constitution is a part of the Bill of Rights, which was ratified on December 15th, 1791. It expresses the principles of federalism, whereby federal governments and the individual states share power by a mutual agreement. This is governed under what we call the laws of contract. Okay? Thank you, Brother Nunley. I appreciate you as well. This is governed under the laws of contract, the laws of agreement between parties, okay? Contracting parties. The 10th Amendment, let alone the other 9 amendments that came before it, prescribes that the federal government has only those powers delegated to it by the Constitution. Now, the Constitution is not a grant. It's an instrument of limitation, meaning that it's an instrument that forbids, stipulates, put a stop to actions contrary to what the language of the Constitution actually states. And all the powers now forbidden to the states by the Constitution are reserved to each state or to the people. Very important that you understand the first step in the process of how the power will be restored to the English people. Okay? The 10th Amendment prescribes that the federal government, when I say the federal government, I'm talking about the Union of States. The some odd states, 50 states, 50 some odd states that there are, prior to to joining the Union, there was only 13 states that were actually called colonies. Okay? So when we're talking about states, we're talking about colonies. Okay? When you say state, it's synonymous with the term colony. It's not an antonym, but it's synonymous with the term colony. So if you're a state citizen, you are in fact a colonist. Okay? You are a immigrant or a naturalized citizen to one who understands citizenship. Or the people. So either it's reserved to the states in their respectively, or to the people. Point blank. All right? So you have to ask yourself, are you one of the people of the state? Once again, are you one of the people of the state? Because one of the people of the state is a national that's not just by blood, but as well as by being born on the soil. Those who are not citizens of the state and claim to be one of the people are citizens based upon their status by some type of naturalization process, which we'll discuss again today, as we discussed in the past. Very important. The text says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Are reserved to the states respectively, or to the people. How many people of you know what the word respectively means? How many of you know what that word means? Let's look it up. respectively. Definition. Let's go to Webster's Dictionary. In the order giving, okay? Not together, but in the order giving, or in particular, separately, means separately, okay? So when we look at that word separately, contrast to the word together, we in fact have a real problem. We have a real problem, okay? So let's go back to the 10th Amendment and read the text again. The text says, the power is the power that is the question that's in question. Who has the power? Is it the respective states or the people? Because it said respectively. And we know the synonymous word for respectively is singly, not jointly, but singly. So it says the power now delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, meaning singly, or to the people. Not together, but singly. Okay? So we know that the state has a definition and the people has a definition. You have to make sure that not just that you're one of the people, but you got to make sure you understand what the word state and make sure that you are in fact a part of the state. Because everyone up to the founding of this country, to the Immigration Act, are not one of the people, in fact, to the states respectively, based upon the true definition of citizenship, based upon the laws governing citizenship. Very important, because people, it didn't say groups of people, it said people. So once again, I read the text in its entirety. The power is not delegated to the United States by the Constitution, which is the instrument of limitations. On the federal level, it's a grant, because the sovereignty that the states had was actually surrendered and given to the United States collectively. So now the states, or the United States in turn, has power to grant power and authority, not sovereign authority or a sovereign grant, but nonetheless a grant, the power to do something with limitation, because the Constitution is not an instrument granting sovereign power, it's an instrument of limitation. Okay? Why? Because the power is supposed to be what? In the people. If that makes sense to everyone watching today, please give me a thumbs up in the chat as I go on with my lesson. Let's define people. Let's get a better understanding. That only makes sense. I'm not going to be here long tonight. Reading Archbishop Belmont from the House of Belmont. The term people. The term the people refers to public. It did not say republic. It said public. Don't get it twisted. Or a common mass of people of a polity. Hence, the last term they said, polity. Thank you, Brother Thomas from House of Thomas, for your condolences. The term the people refers to the public in general, i.e., the common mass of people, the people of a polity. So that means that the state and the people are one. But when we read it in the 10th Amendment, it said respectively. And the people were the latter. They were not the former. So it meant that you surrendered the power that was formerly to you to the latter, which was the state, because they were put in place to represent you. So the term the people and the state are not synonymous. Okay? Once again, the term the state and the people are not synonymous. The term people refers to the public, not republic, public being a common, not just a mass of people, but a common mass of people, meaning that they got one thing in common that they understand. And what is that? The polity, the government. All right. As such, it is a concept of human rights, laws, as well as international law, domestic, non domestic, as well as constitutional law, particularly used for claims of popular sovereignty. In contrast, a people is any particular of persons considered as a whole. Used in politics and law, the term people refers to the collective community of a ethnic group or nation. Did y'all hear that? Of a ethnic group of people that belongs to a group based upon their nation. It has to do with genealogy or race. Okay? That must be understood. Not just because we say so, but because the law says so, whether they're domestic laws or international laws or constitutional laws or statutory laws or just common law, which we know is precedent. All right? Must understand that. Okay? So we understand the people as defined in the definition of people is an ethnic group of the mass of people that originated from one nation. Everyone needs to write that down, drill it, do whatever you need to do with it, lock it up, put it in the box, do something with that information that I just gave you. All right? Because it just said the term of people refers to the public, not republic or a commonwealth or an interregnum or an overthrow or a revolutionary republic, which is something created as a result of overthrowing the law or outside of the law. So that's what you have now. Because it didn't say republic, it said public. So that means the public is the people and not the republic. Majority of the people are part of the republic, so you are not a part of the mass of people that's part of the polity. They know it. You're the only one that don't understand that. Okay? How we know that? Because once again, the very first sentence, the term the people refers to the public or common mass of people of a polity. So we understand that the 10th Amendment, as we read it and verbatim, says the powers delegated to the United States nor prohibited by it to the states, meaning if the states didn't give it to you, then you can't use it. All right. If the states gave it to you, that meant that there's a contractual agreement between you and the states, which means that the state has surrendered some of the sovereignty, i.e., some of the autonomy that they had, whether you're talking about the states respectively or the people who make up the states. Very important that you understand that as we go forward. Now we looked up people. Now we look up state, because we know that people are the mass of people or the common people of a polity. So what is a state? Let's define that. Everyone needs to write that term down. State is a political entity that regulates society and the population within a defined territory. Government is considered to form the fundamental apparatus of contemporary states. Okay, hold that thought. I gotta plug my. Sorry about that. So a state is a political entity that regulates society, the population within a defined territory. Government is considered to form the fundamental apparatus of the contemporary states. So states and polity are one and the same. Okay? The word state and polity are one and the same. We must understand those definitions. Over time, various forms of states develop, i.e., body of politics, that use 1 second. Okay. Over time, various forms of states develop that use many different justifications for their existence. We're talking about polity. We must understand that because if you're one of the common people or of the mass of people that's common to the polity, you must understand the structure of your polity because it's in a contractual agreement. When you're talking about the state level or on the federal level, it's a contract between the state, i.e., the United States, or the United Colonies, or the people. Whether you're talking about immigrants, or whether you're talking about the nationals, or whether you're talking about somebody who just there ain't supposed to be there. Okay? This is all something we need to understand. Greetings, Brother McGarry from Dr. McGarry. All right. So over time, various forms of states develop. When we say states, we're talking about body of politics. When you're talking about each individual state, or you're talking about the United States, which has one body of politics. Okay. You have to make your connection to that body of politics, and it must be based upon either the color of skin, because if we go to the Naturalization Act of 1790, it ain't had nothing to do with genealogy or ethnicity or race. It had to do with your color of skin. Okay? The immigration had nothing to do with your race, genealogy, or ethnicity. It had to do with your color of skin. Okay? So there's nothing that's divine in that. There's nothing that's social in that. There's nothing that's political in that. It all has to do with a class, a status. Okay? So once again, over time, various forms of state developed that use many different justifications for their existence, such as the divine right, the theory of the social contract, etc. Today, the modern nation state is the predominant form of state to which people are subject. Sovereign states have sovereignty, and any group claimed to have a state faces some practical limits via the degree to which other states recognize them as such. Satellite states are states that have de facto sovereignty, but are often indirectly controlled by another state. It means a subordinate state. Okay? This you must understand and lock into your psyche. And if you're going to go on, we'll be able to understand that the 10th Amendment is how the power is going to be restored to the English people. Okay? This is the title, this is the aim, this is the objective, this is the cause, this is going to be the outcome. Right? So we define people, we define state as expressed in the 10th Amendment, whether you talk about on the federal level, on the state level. Okay? The power is in the people. Okay? Now we understand that when we say people, it specifically mentioned those of ethnicity and of nationality. Okay? So those are the topics that's on the table today in regards to truly identifying yourself if you are one of the people and if you are part of the body of politics. Okay? Very important. All right. So the 10th Amendment. Now I got how many cases I got here? One, two, three, four, five, six, seven. All saying the same thing about the 10th Amendment. And you know what it says? It says powers not delegated to the federal government should prohibited by or so those prohibited by the states are reserved for the states or the people. Okay? So let's identify the people that we're talking about based upon the meaning of the 10th Amendment, going from Article 1 to Article 9, because without 1 through 9, you'll have no 10. Okay? And the First Amendment is religious freedom. Okay? Religious freedom, religious protection, God's protection by God's law. This is very, very, very important. This is what you need to make your decision if you're going to be one of the people of the politics that you choose, because we know that there's a separation of church and state. Okay, there's in fact a separation of church and state. So you want to see what body of politics that you are a part of as included as one of the people, because you got either or. You got the state or you got the church. Okay, you got the what they call the uh uh you got different type of churches. Okay, you got non-charitable, you got uh uh religious faith. I mean, which one? All right. If it does not involve a polity, then it does not involve a state, then it does not involve anything associated with your ethnicity or religion. That is most paramount for you to understand. Okay? Let's get it. Chisholm versus Georgia. All right, let's go here. Chisholm versus Georgia. Matter of fact, let's go here. This is what the Supreme Court said. This is what the Supreme Court said in the case surrounding the arguments of the executive order of 14160 by Donald Trump, which came out in favor of Donald Trump in regards to the issue dealing with universal injunctions, which have to be brought forth in their purport to those making their claims versus the state acting for international injunction based upon how they feel as though that on the state's interest. Okay. Now it's very important to understand Chief Justice Sotomayor's dissent in regards to the arguments raised on lieu of the executive order, because no one want to deal with the validity of the executive order. They just want to argue the injunction argument, which she clearly states that, and I read in its entirety, that is, and even if the majority is correct that courts in England at the time of the founding were so limited, I have my doubts. So anti at 18-20 Shalimar J. dissenting. Why would courts in our constitutional system be limited in the same way? Question. The founders of the United States, okay, of America, squarely rejected a governing system in which the king ruled all and all others, including the courts, which were his subordinates. And our Constitution center system, the people are the rulers, and we have the rule of law. Once again, going back to the 10th Amendment, state means polity, and people means ethnic or nation, genealogy, just soil, etc. Okay, so if it says the power that United States or the state have is respectively for either one and not jointly, then we have a problem. Okay, because the people are left without a voice. The voice is the power of the language of the law. Okay, because the law is the supreme law of the land. So we see that the people are the rulers and we have the rule of law. So it makes a little sense to look to the relationship between the English courts and the king for guidance on the power of our nation's judiciary, vice in the executive. Okay, so they already understand the argument. They're just not going to talk about it. See the Federalist number 69 at 416 A. Hamilton. Explaining how the president differs from the king, including because the person of the King of Great Britain is a sacred and inviolable. There is no constitutional tribunal to which he is amendable. Indeed, it is precisely because the law constrains the government and our system that the judiciary assignment is so broad per the Constitution. Federal courts entertain suits against the government claiming constitutional violation. Once again, the Constitution is not an instrument referring to a sovereign grant. The Constitution is an instrument of limitation. When the state gave up their sovereign power, some of the sovereign power they had, they allowed and gave to the United States government, which in turn claimed to have granting power to give to their creation, i.e., their branches, their departments, their agencies, etc. Totally different from the power of the state. When we say state, we're talking about body politics, which is not the people who put these people in place, because you are not one of the people in regards to when they spoke about people and reference to ethnicity, nationality, race, etc. We must understand that. So with that in mind, let's go here. We got 7 cases in regards of the language of the 10th Amendment. Let's read it in their entirety. Smith versus Pinto. This is Smith versus Pinto, 1979, Supreme Court, New Jersey. Supreme Court, New Jersey. It states when a state statute is challenged on a state's constitutional grounds, the nature of a state government and the distribution of sovereign power within it makes the plaintiff's burden a heavy one. Unlike the federal constitution, the state constitution is not a grant, but a limitation of powers. Did you hear that? Unlike the federal constitution, the state constitution is not a grant, but a limitation of power. So that's the 10th Amendment, the language of the 10th Amendment, right there in this case. Okay? The federal government possesses only those powers ceded to it by the states and the federal constitution. The state possesses all the other powers of the government, respectively. If the states don't have it, respectively, i.e. body policy, then guess what? It belongs to the people. So if the people are not associated with the states, i.e. the body politics, because of respectiveness of the body of politics, i.e. the state, then what rights do you have? If that makes sense, please somebody give me a thumbs up in the chat line. That's one case I found. Here go another case. In-way application of the Lamb. Finally, we should not lose sight of the fact that unlike the Constitution of the United States, ours in all these cases coming from New Jersey, brothers and sisters, all of them, everyone I'm going to read tonight comes exactly from New Jersey. New Jersey was the foundation for the Declaration of the Independence of Great Britain, from which which preceded the United States Constitution of 1789. Okay, so we must understand that the language of the states of every state in the Union and prior to the Union is based upon the language that says, finally, we should not lose sight of the fact that unlike the Constitution of the United States, our state's constitution is not one of grants or delegation of powers, but is regarded as one of limitations or restrictions of powers. You hear that? The Constitution does not give the state power, it limits the state's power. The power, why? Because it belongs to you. You can't use your power if you're not recognized as the power in that body of politics. Okay? The state legislature represents the sovereign people, and its power are residual. What the people have not said in the organic law, their representatives shall not do, they may do. Did you hear that, brothers and sisters? Apparently, they didn't, because I only see one thumbs up in the chat line. Okay? If that didn't convince you, let's go to another case. Hill versus City of Summit, another case from New Jersey. This is from the appellate division. This is from the appellate division. In determining the constitutionality of a statute, we should consider certain fundamental principles, i.e., a state's constitution. You hear that? A state's constitution. Unlike the federal constitution, it is not a grant, but a limitation of legislative power. The state's legislature exercises a portion of the sovereign grant residing in the people, i.e., what people? Because we got all types of people here, and as we've read the term people, It has to do with the common mass of people. Okay, common mass of people is the people of all of one nationality, and you can't say these nationalities are the immigrants because immigrants came here from all nationalities. When you become a United States or a state citizen, they don't give a darn about the nationality. They don't give about the parents' descent or your mother or your father. They can care less about it. Why? Because they are violating the will of the people. Why? Because in order for to be the will of the people, you must be a part of the body of politics. You are the sovereign power. Okay? Whether you are the sovereign or the one you chose to be the sovereign. 1 second, hold that thought. Sorry about that. It says in determining the constitutionality of a statute, we would consider certain fundamental principles, i.e., a state's constitution. Unlike the federal constitution, it is not a grant, but a limitation of legislative power. The state legislative exercises a portion of sovereign power resting in the people, subject to the limitation imposed by the federal constitution and the state constitution, and those so fundamental in the social compact as to be necessarily implied. A constitutional provision against the exercise of a particular power is in the nature of an exception, and a legislative enactment will not be declared void unless its repugnancy to the Constitution is so manifest as to leave no room for reasonable doubt. Okay? Here's another case. So that's 1, 2, 3, 4. Here's a fifth one. Vereen versus Byrd. 1977 case, so it's every bit applicable. Oh, you don't like this one. It must be remembered. Y'all really gonna like this one. It must be remembered that a state constitution, this is 1977, unlike the federal constitution, is not a grant, but a limitations of legislative power. The functions of the legislative is to exercise a portion of the sovereign power residing in the first instance in the people, subject to the limitation imposed by the federal constitution and our own, as well as those so fundamental in the social compact and the Anglo-Saxon principles of natural justice as to be necessarily implied in the determining in the operative scope of the constitutional limitation. Courts are enjoined to collect the sense and the meaning of the clause, the goal being to ascertain the intent of the people and imposing the particular restraint. Did you hear that, brothers and sisters? They didn't say just any people. They said one people, the Anglo-Saxon principles of the Anglo-Saxon people. Okay? We must understand that. Let's get another case. Russell versus Wells, Supreme Court, New Jersey. It has been held that a state constitution is not a grant, but a limitation of legislative power, that it is presumed that the words employed have been carefully measured and weighed to convey a certain indefinite meaning, with as little as possible left to implication, and that the constitutional limitation upon the exercise of legislative power must be clear and imperative. Did y'all hear that? If you heard it, then what the hell is the people's problem? I know what their problem is. They don't know the English. They don't know the English Anglo-Saxon. They don't know the Anglo-Saxon. I just got a criminal offense that gives the second degree offense 5 to 10 years. I got dismissed with a $120 fine, and I'm appealing that. $120 fine, and I got that charge dismissed, pro se, without the need of counsel. And I'm appealing that because they wasn't supposed to decide if I was guilty in that court of law. It should be in the court of chancery where the matter is being appealed at to this day in time. And here's the last point: Trenton versus New Jersey. Trenton versus New Jersey. In New Jersey, it has been held that within the limits prescribed by the state's constitution, the legislature may delegate to municipalities such portions of political power as they may deem expedient without withholding other powers, and may withdraw any part of that which has been delegated. Van Cleve versus Passaic Valley Sewerage Commissioners. In the absence of a state constitutional provision safeguarding it to them, municipalities have no inherited power of self-government, which is beyond the legislative control of the state. A municipality is merely a department of the state, and the state may withhold a grant or withdraw powers and privileges as it sees fit. However, great or small, its spirit of action, it remains the creature of the state, i.e. the municipality, exercising and holding powers and privileges subject to the sovereign's will. Okay? This Trenton, we know Trenton is the municipality of the state's corporate government, which overthrew the de jure government in 1776. Okay, the de jure government was an indefinite government, which was not a temporary government or a provisional government. It was the government of the people. When the people didn't exist, the government maintained because it had a divine will to exist. Okay, it can only be expressed by divine people. Okay, so it said, in the absence of a state constitutional provision safeguarding it to them, municipalities have no inherited right of self-government, which is beyond the legislative control of the state. When we say state, we're talking about body politics. We're talking about body politics. We're talking about the representative. We're talking about the representative. We're talking about those who the people chose to speak on their behalf. If you did not choose them, they should not be speaking for you. If they are speaking, 9 times out of 10, they don't know what they're talking about. All right? We have to make this make sense. All right. Let's go here. We see here, Naturalization Act of 1790. Because if we're talking about the body of politics and we're talking about the people, when we're talking about the body of politics, we're talking about the people, we must be specific about what people. Because the people that we're talking about in 1790 was only talking about white people. Okay? It include free blacks. It include white Chinese, white Asians, dark-skinned Asians, Muslims, etc. And it include anybody but what we call white people. And it was not a nationalization act, it was a naturalization act. The word national at that time did not apply because they were not a nation at that particular time. Okay? It's very important to understand that. We, in fact, were a nation as a result of the 14th Amendment. What is the 14th Amendment? The language of the 14th Amendment, Kelly says that the 14th Amendment to the United States Constitution was adopted July 9, 1868, as one of the Reconstruction's amendment, considered one of the most consequential amendments, and addresses the citizenship rights and equal protection under the law at all levels of government. That means on the state level and federal level. The Reconstruction Amendment was specifically for the citizenship status, not just soil. Because if it was just soil, it would be just it will be under Title 8 United States Code 1401. You're not subject to Title 8 United States Code 1401 because that type of nationalization is based upon naturalization, which goes back to the Naturalization Act of 1790. So they decided in 1790 that and when they created the Naturalization Act under Title 8 United States Code 1401, they made you citizens under their body of politics as persons identified. Okay? When we talk about the 14th Amendment, we're not talking about the Naturalization Act of 1790. Very important. So when we say the Naturalization Act of 1790, we're talking about the Title 8 of the United States Code 1401. That is the naturalization identity that they have given you under the auspiciation of naturalization. Okay? This is what they call national. They're not talking about the 14th Amendment considered under Juan Kim Ark in the history in light of the common law of England. Okay, very important. So Title 8 United States Code 1401 only deals with those naturalized citizens who have become nationals based upon the nationals based upon the Naturalization Act of 1790, which is the new identity to identify nationals that had nothing to do with a race, ethnicity, genealogy, etc. It had to do with the color of skin, which they allow other people of color of skin to fall in that classification. Now, we as people identify as black people, that's your choice. If you want to fall in that classification, hey, ain't nobody stopping you. Okay, you don't have to though, because your birthright is already preserved from you under the common law of that land, which was the English law, all right, as prescribed by we the people. Okay, under our body of politics. Okay, under our representatives of the body of politics, which at this particular time happens to be a king. All right, let's move forward. Then we have the Immigration Act. Everybody heard of that, right? Of 1924. So you got the Immigration Act, and they had quite a few of them, okay? And all of the Immigration Acts passed by the federal government, it identified every other naturalized citizen who immigrate to North America and became national under the Naturalization Act or under some type of naturalization process that they have based upon whatever amending that they have done to the law. Okay, very important. So we have three classifications. We have the Naturalization Act of 1790, which had nothing to do with ethnicity, genealogy, race, etc. Then we had the 14th Amendment that did have to do with race, ethnicity, genealogy, if you understood it in that context. And then you had the Immigration Act, which you spoke of. So let's examine the 14th Amendment, how you should examine it based upon not just soil, but just St. Greenius, because you are in fact in England. Okay, let's see as I come to my closing. United States versus Juan Kim Ark. Before that, let's make sure we know what American citizen is. This is all common law. We should all ask ourselves that Sing Tung Du or Juan Kim Ark or Dred Scott or anybody for that matter that's subject to the reprimanding of what ISIS and the government is doing. You ask yourself this question: must an American citizen seeking to return to this his native land be compelled to bring with him two witnesses to prove the place of his birth, or else be denied his right to return and all opportunity of establishing his citizenship in the courts of his country? Okay? No such rule is enforced against an American citizen of Anglo-Saxon descent, if this be as claimed a government, i.e. a state, i.e. a body of politics of laws and not of men. Okay? So hell with men, because some men don't go by the law, and some men are lawless. Okay? So we have to choose our leaders as Deuteronomy 17:8 verses 8 to 19 stated. I do not think it should be enforced against any American citizen, even in Chinese descent, if you know the law. Okay? But it specifically said an Anglo-Saxon citizen identified in this territory now called America does not need anything to prove that he is in fact a citizen based upon his descent. Not because his color of skin, but because of his descent, his race, ethnicity, genealogy, as defined in the definition of the word people. Ethnicity, nation, nationality, etc. It didn't say naturalized, y'all. It said nation. That is very important to understand that, especially where I'm trying to go next. All right. United States versus Juan Kimar. Let's look there right quick. Now, this is case law. And I'm also going to show you legislation back in the case law. This is Juan Kim Ark. This is what the Supreme Court was talking about in the dissent from Chief Justice Sotomayor. It says both in England and the United States, indeed, statutes have been passed, not common law, not a group of people sitting up talking about what they think citizenship and the status of citizenship, whether you're talking about just so or just sanguineous. They said both in England and the United States, indeed, statutes, and we know statutes are derived from legislation, okay, have been passed at various times, enacting that certain issues born abroad of English subjects or of American citizens. Now we go back to United States versus Singh-Do. They said American citizen was what? Anglo-Saxons. And we don't have to prove our citizenship. So that speaks even further to who the subjects are now called American citizens, respectively. You hear that? Respectively. There go that word again. Should inherit to the same extent, at least, the right of their parents. Not just because you're born here, but because your ancestors were here. But those statutes apply only to cases coming within their purport. So if you don't raise the argument, guess what, brothers and sisters? The argument is therefore raised. All right? We're raising the argument. Why? Because Edward the First, Edward the Second, Edward the Third told us that we can raise this argument. It's called a petition of right. All right? How we know it? He's going to mention the legislation that we are able to use that United States Juan Kim Ark is based upon. It said, where's it at? It's the English king. There is no matter of doubt that the children of our Lord, you hear that, brothers and sisters? You can look at it in the abstract, you look at it in the concrete. We take it both ways, okay? Our Lord was the king, all right? Whether they were born on this side or beyond the sea, we call that littoral rights or referendum rights, should bear the inheritance. It's a birthright, y'all, of their ancestors. We're talking about those dead and gone in regards to other children. And it was agreed in this parliament, i.e., government, i.e., body policies, i.e., policy, that they should inherit whatever they might be born in the service of the king. So if you're not serving the king, you don't have an inheritance. Why? Because it's not conveyed to you through the process called lottery of season, which is under 46:3-9, which is a solemn oath of allegiance to the king, to the law, and to the supreme law of the land. But because Parliament was about to depart at that particular time, as a result of the 100-Year War, the War of the Roses, or the Black Plague, the business demanding great advisement and good deliberation how it should be best and most surely done. The making of the statute was put off to the next Parliament by reason apparently of the prevalence of the plague here in England, brothers and sisters. No act upon the subject was passed until Edward III, when Parliament passed an act entitled "A Statute for Those Who are Born in Parts Beyond the Sea," by which, after the reciting that some people be in doubt, and if the children born in their parts of the beyond the sea out of the legions of England should be able to demand any inheritance within the same legions or not, whereof a petition was put forth in the Parliament of Edward III, pardon self, in Parliament of Edward III, and as to at the same time wholly assented, and it was agreed and affirmed that the law of the Crown of England is and always has been such that the children of the King of England, in whatever part they are be born, in England or elsewhere, be able and ought to bear the inheritance after the death of their ancestors. Okay? It's right here and 1898, there's a case that's still prevalent based upon citizenship exclusively and inclusively for the children of slaves. Okay? For the children of slaves. You must understand the transition. Based upon what time? Let me go further. 1350. Where is that? Did I go by it? I went by it. What is the date that was agreed upon? 1350 until the 5th Edward III, 1350. This is this actual legislative act of our forefathers, their government, their body politics, under their sovereign authority, in which we have reenacted through our certificate of incorporation, which I'll close on in a second. Let me just find it right here. The Natit Otremayer. Okay, this is this enactment right here. You see that seal behind me? You see that seal behind me? That's the same seal here. It's an act of our government. All right? We stand on the acts of our government. That Natit Otremayer, also known as the Statute of Children Born Abroad, an act in 1350, was an English statute during the reign of Edward III. It regulated the rights of those born overseas and was an early precursor of British nationality laws and others, dated from 1351 during the early part of the 100-Year War, which was the War of the Roses, brothers and sisters. It also went on to set the standard of the precedents for other matters in regard to citizenship, going all the way back to Calvin Case, even the Naturalization Act of 1790, the 14th Amendment, as well as the Immigration Act of 1924. Okay? This you cannot dispute. It says the statute of Edward III was invoked over 200 years later in two matters. In the first of those, it did not prove effective since the outcome went to other directions, but in the second was in regards to the significance, in regards to the succession of Elizabeth I, where it goes into the founding of King James, the sixth king of Scotland and the first king of England, claiming his right to the throne under the divine rights of king. Henry VIII claimed his right to the throne under the divine rights of king. Okay, but none of them was divinely prepared by God, i.e., the king, because they were not kings of England. All right. It was also brought up to argue against the proposed right of an inheritance in England of the causes post-denied those born after the union of the crown in 1603. I just said it. Okay, so you must know your history in order to put this puzzle together. And we'll close out on this. Let's see where I was going. Let's go here. Lee versus Harris. All right, it's a good case. Supreme Court, New Jersey. Listen, everybody. Now we know Chisholm versus Georgia says that. Matter of fact, I got it right here. I got two more cases to read for you, then I'll close out. Listen. You find the same language in the common law, Chisholm versus Georgia, and New Jersey by statute 46-3-2. King of England, body of politics, corporate or person. Okay? King of England, body of politics, corporate or person. That's in a statute. We're reading it right here in common law precedents. This is the only law concerning corporations to which I can conceive the least reference is to be had in the common law of England on that subject. I need not repeat the observations I made in respect to the observation of that law in this country, meaning the laws of England operate in this country, the country called America. The word corporation in its largest sense has a more extensive meaning than people generally are aware of. We talk about the people. Any body of politics. You hear that? Any state. Any government, because that's synonymous, state, government, body politics, or polity, same word. Any body politics, sole or aggregate, whether it's powers, we're talking about powers, be restricted or transcended, we meaning talking about limitations, is in a sense a corporation. You hear that? When you're talking about a group of people or one person, they are all corporations, whether their power to be limited or transcended, they are subject to the powers called corporate powers, okay? And all corporate powers derive their authority from a corporate or sovereign grant, okay? And we just read the federal government and the powers that were granted to the federal government are not actually sovereign grant or sovereign powers to grant. Those are the granted powers that came from the state, and the state was the body of politics without the people there, and the people are sovereign. So if the people don't put the people in the body of politics to set the standard for the people and those who gonna serve the people, then hell, you just got the wild, wild west going on there. So it clearly says that the word corporation, in the larger sense, has more sense to meaning than people are generally aware of. Any body of politics, state, government, polity, whether it's a corporation sole or aggregate, whether it's the power to be restricted or transcended, which means limited or what we call indefinite, okay, is in a sense a corporation. The king, accordingly, in England is what? Called a corporation. Also, by a very respectful author, is Parliament itself, i.e., that's the body of politics. So you're talking about the person and the body of politics, okay? It's called a corporation. The king, according to English, called a corporation, also by a very respectful author, is the Parliament itself. And this extensive sense not only each state singly, we're talking about the state, but even the United States may without impropriety be termed corporations and have therefore in contradistinction to the large and indefinite term used the term subordinate corporation, meaning to refer to such only also capable of the slightest application for the purpose of the objection, with whose creation and whose powers are limited by law. All right, as those 8 cases we just read, that the state's powers or the state's constitution that gives them the power is not a power to grant, it's a power of limiting their authority. The difference between such corporations, body of politics, state, government, whatever you want to call them, let's read it. The difference between such corporations, because they're all corporations, we're going to qualify that. The difference between such corporations in the several states in the union. So they talked about jointly as relative to the general government are very obvious in the following particulars. First, a corporation is a what? Mere creature or of the king. You hear that? A corporation is a mere creature of the king or a parliament. Okay, so if the king ain't there, it's parliament acting in the absence of the king. Very rarely is of the latter, i.e., parliament. Most usually of the former only. It owes its existence, its name, its laws, except such laws that are necessary incidents to all corporations, merely as such, to the authority which created. I need not say more. Okay? Now we go to Lee versus Harrison. Okay? And closing. Lee versus Harrison. Corporate powers have their origin in sovereign grant. Okay? Generally, they are derived from the Articles of Incorporation and the laws of the state under which the corporate body came into being. A corporation has those powers which are implicit in the charter as well as those which are expressed. Authority not reasonably within the corporate grant is excluded, meaning if it's not mentioned, it's not going to be entertained. But whatever may be fairly deemed an incident of the power expressly confirmed by that charter, i.e., certificate of corporation, within the grant, unless expressly prohibited, instrument is to be received a reasonable construction and serve the general end of the views. There is no distinction in this regard between nonprofit and business corporation. It is considered that the doctrinal qualification for membership prescribed by the bylaws will be effective where the charter itself was expressive of the self-same standard. Okay? So with that, make sure I covered everything. Let's go on Deuteronomy. Deuteronomy 17:8. This is the scripture. Deuteronomy is the last 5 books of the Bible, the Hexateuch. We go to verse 8. We're dealing with the courts of law. Okay? The courts of law. If a case comes before your court that are too difficult for you to judge, whether bloodshed, lawsuits, or assaults, take them to the place the Lord, your king, your God, will choose. Go to the Levitical priests and to the judges who is in the office at that particular time. That means when you go into a court of law and you go before your Levitical priest, your magistrate, your judge, inquire of them, and they will give you your verdict, meaning due process of law. You must act according to the decisions they give you at the place your Lord will choose. If your Lord ain't there, the Lord ain't going to hear your call. This is called a petitioner right to your Lord, which in this case will be the king. And in order for it to be petitioned to the Lord, the king, it will be in the king's court. Whether the Lord there, the king, or his officers, this will be the judges. Be careful to do everything they instruct you to do. Act according to whatever they teach you and the decisions they give you. Do not turn aside from what they tell you to the right or to the left, meaning stay your course. Anyone who shows contempt for the judge or the priest who stand ministering there to the Lord your God is to be put to death. You must purge the evil from Israel. All the people who will hear be afraid and will not be contemptuous again. So what this is saying that you will be judged accordingly. Those who come within their purport based upon their claim will be heard based upon their claim or how they petition their overseer or the one who overseer put in place of them. In this case, it will be a king because it's right here in Deuteronomy. It says, and I enclose it. When you enter, and they're talking specifically about me, okay? Me. Because everything we just read in the prior verse depends upon what's happening in this verse, okay? If the king can't do it, then nothing you do in court is going to help you because you don't got the right to petition, but those who you put in place to petition to. Okay, that's why I said the powers not granted to the United States are reserved respectively for the states or the people. And the people must put the people in positions in the state government, party, etc., whatever your choice is, to be able to be heard. So it says, when you enter the land your Lord God has given you and have taken possession of it and settled in it, and you say, let us set a king over us like all other nations around us. We talk about nations. All the so-called representatives of this so-called nation are not, one, kings, two, they're not of your nationality, three, they don't know your language. Why? Because you don't even know the language. Be sure to appoint over you a king the Lord your God chooses. So we all run around talking about we the chosen people and that we got leaders who speak on our behalf. I beg the difference. Beg to differ. He must be from amongst your fellow Israelites. Today we call by another name. We're called the Anglo-Saxon Berbers. Do not place a foreigner over you, one who is not an Israelite. The king, moreover, must not acquire great numbers of horses for himself or make people return to Egypt to get more of them. For the Lord has told you, you are not to go back that way again. He must not take many wives, or his heart will be led astray. He must not accumulate large quantities of silver or gold. What this is telling you that we must not repeat our transgression. We must not repeat our actions that we have repeated continuously and continuously and continuously. Why? Because we don't have a leader. So if you understand the language of the leader, and if you are my sheep, hear me when I call, because the time is here. So with that, I'm gonna greet you as I always greet you, and that is in peace and love. Thank you all for your